My name is Julie Han, and I am managing partner of the team company based in South Korea. I hope everyone is coping well in this difficult time. 요즘 코로나로 모두들 많이 힘드실 텐데 다들 힘내시길 바랍니다. Yes, there's one so far for the construction industry. On April 28, the Korean government passed a revision to the enforcement decree of the Act of Public Contracts. This, which is to provide a temporary relief to the parties of the public contracts in response to COVID-19, eases the procedure of contracts involving the government. On February 12, the Korean Ministry of Economy and Finance issued a guideline for handling public contracts to respond to COVID-19. Under this guideline, if a contract can't be fulfilled within the time agreed due to COVID, a contractor may be released from paying liquidated damages. And then 2 weeks later, on February 28, the Ministry of Land, Infrastructure and Transport released an official interpretation treating the situation around the time arising from responding to COVID-19 as epidemics under the force majeure clause provided by the standard form contracts in private construction projects. If a contractor cannot perform due to COVID, the ministry's interpretation allowed him to ask for extension of time as well as adjustment of the contract price. Korean construction companies are making rapid changes in response to COVID-19 situation, such as having virtual meetings, which are now being common, and employing automation and modularization in construction technology, all of which will likely have influence on their overseas projects in the coming future. Korean construction companies' ability to quickly adapt themselves to changes will help them find their spot as leaders, making the necessary changes in the global market. But at the same time, Korea's contractors and engineers are closely observing the measures other countries are taking in handling this pandemic. Unlike in the Korean domestic market, where the policy is working to normalize the economic activities, the overseas projects carried out by Korean companies are suffering damages, not only due to virus itself, but also because of the foreign government's unpredictable measures. Now with such problems, playing as a precedent of a possible risk, bid prices or tender costs of future projects in those countries are likely to go up, making Korean contractors and engineers reluctant to undertake new projects, I believe. First, contractors need to understand the causal relation of the damages when they arise. When looking at COVID-19 from the contractual standpoint, damages in the projects arose due to the combined reasons of force majeure, change in law, and suspension. Contractors need to identify the cause and effect of the particular event, and based upon that, may duly claim the right. The team's next advice is to observe contractual mechanism. So, contractors need to observe the contract procedure and fulfill contractors' duties as provided by the contract. Asking entitlements only without complying with the rules and procedure would appear unreasonable, and that's not helpful to resolve dispute. And lastly, we recommend contractors to accurately analyze the loss. In calculating the loss due to COVID-19, the methodologies we can consider are the analysis of delay, disruption, and quantum. If the loss can be reasonably calculated using the most practical analysis method, And if the parties at dispute can find the middle ground at the claim stage, then there's no need to run to the arbitral tribunal. I hope I have given a lot of helpful information for anyone watching or listening to this interview. And if you have any other questions, please contact the teams of public relations at inquiry at the-team.kr. 좀 더 많은 정보를 원하시면 저희 웹사이트에서 참고해 주십시오. Thank you. 감사합니다.